this video. And everything that's going to be mentioned in this video is being brought to you under the Declaration on the Right and Responsibility of Individuals, Groups, and Organs of Society to promote and protect universally recognized human rights and fundamental freedoms. And through this video, we are going to discuss and study and form and hold opinions on the observance, both in law and in practice, of a certain human right. And we are going to draw public attention to that matter. The DRR, Article 3, Domestic Law, consistent with the Charter of the United Nations and other international obligations of the state in the field of human rights and fundamental freedoms, is the juridical framework within which human rights and fundamental freedoms should be implemented. So it's very clear, right? We are being taught and we are to know that domestic law, the law of the country that we are living in, this domestic law is the framework, is where human rights and fundamental freedoms should be implemented. There is an obligation upon the state party that through their domestic law, consistent with the charter, meaning the international covenants, this is the framework that is to come forth to bring forth human rights and fundamental freedoms. Looking into the International Covenant on Civil and Political Rights, Article 2, Subsection 2, where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So the international article is telling us that if our fundamental rights are not being respected through legislative, which is statutory, or other measures, then the state party is under the obligation to take the necessary steps in accordance with its constitutional process and with the rights that are present in the covenant to adopt such laws or other measures. So two things, right? They can adopt laws or they can adopt other measures as may be necessary to give effect to the rights recognized in the present covenant. So there is a legal obligation upon our countries that they must adopt laws or provide other measures to make sure that the rights that are enumerated and listed and brought forth in the international covenant are given effect in domestic law. And when you're talking about domestic law, when you're talking about your country's law, there's only two types of law in operation. That would be foundational law or statutory law. And the obligation is that within these laws, you must provide a measure. You must provide an avenue for an individual to exercise their fundamental rights. R versus Hines, 1999. This is 17 years after the advent of the Charter here in Canada. Prior to the Charter's advent, the individual really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or legislative arm of the state. There were no means at the disposal of an individual to muster court challenges aimed at invalidating legislative, executive, or administrative acts. So what type of pronouncement is a judge making here by writing this paragraph? Well, he's admitting and he's saying that in Canada, before the Charter came into existence, that we as individuals, we had no ability to protect against incursions that happened against our fundamental rights. Why? Because Canada didn't care about our fundamental rights. That's why there was no operations of law. That's why there was no measure in domestic law to help us when they would create laws, or to help us when they would come after us and breach our fundamental rights. So the judge is saying, and the judge is showing us how messed up Canada really is in their law by stating this paragraph, by telling us before the Charter came into existence, oh, there was nothing out there that protected the individual if we limited and abridged their fundamental right. In fact, the judge goes on to say, public order mandated compliance with directive and ordinances, even if they infringed upon individual fundamental rights. So their laws in Canada, the way they set them up, right? They mandated compliance. They could care less about your individual human right. And that's the real heart. And that's the real face of those behind the Privy Council, of those who are really running our country. That's their true colors. But now, domestic law, in accordance with the Charter, this is the framework which has to be implemented so we can express our human rights. It should be implemented for the promotion, the protection, and effective realization of those rights. That's the obligation upon them. Article 6 of the DRR. Everyone has the right individually to know, seek, obtain, receive, and hold information about all human rights, including having access to information as to how those rights are given effect in domestic, legislative, judicial, or administrative systems. All right, so the DRR is now telling us, right, that our rights are given effect in one of three ways: through legislative, judicial, or administrative systems. Everyone has the right, the man or the woman has the right to have access to information as to how those rights are given effect in domestic, legislative, judicial, or administrative systems. We have the right to have the information. We have the right to know. We have the right to understand. How is it that our fundamental human rights are given effect in domestic laws? International Covenant on Economic, Social, and Cultural Rights, Article 13. The state parties to the present covenant recognize the right of everyone to education. They agree that education shall be directed to the full development of the human personality and the sense of its dignity, and shall strengthen the respect for human rights and fundamental freedoms. So what is this saying? Well, they had the obligation to teach you about human rights. And they had the obligation to teach you how human rights are given effect in domestic law. But they never did. Continuing on in Article 6, as provided for in human rights and other applicable international instruments, freely to publish, impart, or disseminate to others views, information, and knowledge on all human rights, to study, discuss, form, and hold opinions on the observance, not just talk about it, both in law and in practice, of all human rights, and through these and other appropriate means to draw public attention to those matters. So an individual can impart and disseminate information, and knowledge on the observance, both in law and in practice, of all human rights, and the individual has the right to draw public attention to those matters, even if it upsets the state party. The DRR, Article 9, in the exercise of human rights, including the protection of human rights, as referred to in the present declaration, everyone has the right, individually, to benefit from an effective remedy and to be protected in the event of a violation of those rights. And that's what some people want. They want an effective remedy. So they go out and they search YouTube, right? And they find some videos. They find some people teaching. Hey, listen to me. I'm going to tell you how to go to court. I'm going to tell you how to invoke common law. You're going to stand as a man. The court's not going to have authority over you. I'm going to tell you what you need to do. And they go and they do these things, right? And they get in worse trouble than they already are. Or they search the internet and say, hey, come file a UCC. Or come file a living trust. Just pay me $5,000 and I'll fix the problem for you. I'll give you a remedy. To this end, everyone whose rights are allegedly violated has the right, either in person or through legally authorized representation, to complain to and have that complaint promptly reviewed in a public hearing before an independent, impartial, and competent judicial. Well, you can go to court. That's what you want to do. You have the right. You can go to court in person, or you can go to court through a lawyer, and you can have your complaint promptly reviewed, or other authority established by law, and to obtain from such an authority a decision in accordance with law, providing redress, including any compensation due where there has been a violation of that person's rights or freedoms. Listen to what it is saying here. Everyone whose rights have been violated can complain to other authorities which have been established by law, and to obtain from such an authority a decision. They are not talking about court. They are not talking about a public hearing or going into a court of law. They are telling you that there are other authorities established by law that are able to hear your specific complaint and that are able to provide redress, that are able to provide a remedy because there has been a violation of your fundamental right. And we're going to get back to that paragraph in just 1 second. But this goes with it. This works together with it. To the same end, everyone has the right to complain about the policies and actions of individual officials and government bodies with regard to violation of human rights by petition or other appropriate means to competent domestic, judicial, administrative, or legislative authorities, or any other competent authority provided for by the legal system of the state, which should render their decision on the complaint without undue delay. Everyone has the right to complain about policies and about actions of individual officials, as well as government bodies, with regard to violation of human rights. So the CRA is an individual official working on behalf of a government body. They are Her Majesty's agent, and they are sending you a notice of assessment claiming that you owe a certain amount of money. Now, this notice of assessment is forcing a contribution from you. It is forcing you to contribute based upon the principle of mutual benefit. Let me ask you a question. Does international law provide the state party an operation of law? Does the international law give to the state party the ability to force you to contribute based upon the principle of mutual benefit? Is there a fundamental principle of justice that operates down there? You have to be able to answer that question yourself. And you have to be able to point to an article of law in international law where you are drawing that right from. So I have the right to complain to the competent authority which has been provided for by the legal system of the state. I have the right to complain to them concerning the fact that my fundamental human right has been violated. And I have the right to ask that competent authority to provide the redress for me, to provide the remedy for me concerning the violation of that right. I'm being told that I must contribute. I must pay into the system based upon the principle of mutual benefit. That's what I'm being told. That I am expected to surrender my fundamental human right to use my wealth and resources for my own family and on my own accord. I am being forced to surrender that right in order to contribute based upon the principle of mutual benefit. And if that's my position, and if that's my understanding, and if that's my claim of right, then the redress that I'm looking for, the remedy that I'm looking for, is to have remission of that debt, is to be declared that I no longer owe upon that assessment. I am looking to have that amount remitted because it is an unjust debt. The debt that has been produced through statutory law is unjust against me because it has limited and abridged my full legal capacity. It has limited and abridged my fundamental human right. That debt is an expression of me being forced to contribute based upon the principle of mutual benefit. And it's being done through statutory law. Therefore, it is unjust. And my redress, my remedy, is to have it remitted. So it makes me wonder, what measure did they provide? What authority is out there? Because the law is saying, right, that you don't have to go to court. That there are other authorities that have been established by law, wherein with you can obtain a remedy, a redress from what's going on concerning the violation of your fundamental human right. And they tell us clearly, right, that it's a competent authority that's provided for by the legal system of the state, that it has the authority established by law to produce the remedy on your behalf. And many people would think, right, well, I got to run to court. Got to run to the court to have my right respected. That's what Billy Bob said. That's what Joe Blow told me. Run to the court and claim your biblical rights. Run to the court and bring a UCC. Run to the court and bring a living trust. Then you're going to get respected. When all along the state party is being deceptive, right? By hiding the remedy in the legislation. By hiding the remedy in statutory law. By providing the redress and then hiding it where they don't think you're going to go and look for it.